Uh, Thank you all for joining us for our briefing today. So, for today's briefing, we'll focus on India's data protection law, which was passed earlier this year in this month in both houses of parliament, and then notified and published in the Gazette. Um, we'll talk about how it impacts citizens, how it impacts companies. And while it's a fairly detailed and comprehensive law with many facets to cover, thankfully, it should be a subject of a conference which we will do a little later in this year. In October, we're planning for the third edition of our MediaNama conference. Today we'll try and pack in as much as possible in an hour or so and talk about things from as non-legal a perspective as possible, even though it's a law. Remember, this discussion is being presented by journalists and not lawyers, so don't excuse the legal advice. And we'll give you our reading of implications. I might jump in into cases talking about the business aspects that I see and challenges for businesses. As always, with our briefings and Q&A will not be recorded. Uh, before I before I begin, I'd like to remind you. Um, sorry. I don't know if you can hear me clearly, but before I begin, I'd like to remind you that we have about 27 articles on the data protection bill out so far, and a couple of others in the pipeline. We had about 13 articles out on day one, and the MediaNama team worked really hard to get out as much like granular analysis as possible, as quickly as possible. Um, so it's all quite comprehensive, and all credit to everyone who's been presenting today's call for the work that they've done. We'll now begin with the presentation, and I'll jump in wherever I have some comments, and then we'll have an open discussion post that. Sarvesh?
Thanks, Nikhil. Um, Thanks for joining us for this briefing call. Just some quick housekeeping. No part of this presentation is legal, business, or investment advice, and the information is selective and not comprehensive. So today we have a lot of ground to cover. We're looking at what are the different things that companies have to do under the Data Protection Act, what rights do users have, and what rights they don't have, what are the role of sectorial regulations, and how is children's data going to be processed, what are the exemptions for the government, the whole structure of the Data Protection Board, its powers, its functions, the timelines for compliance, the impact on the RTI Act, and how the Act has finally turned out from the previous, in comparison to the previous iterations of the Data Protection Bill. Just some quick definitions that are a recurring theme throughout the presentation. One is, of course, personal data, any data about an individual who is identifiable by or in relation to such data. The other important definition is data fiduciary, where it's defined as any person who determines the purpose and the means of processing of personal data. And the person can be an individual, it can be a company, it can be a firm, it can be a government entity. The other important definition, data principal, which refers to the user to whom that personal data relates to. And when it's a child or a person with disability, it's the lawful guardian of that user. Data processor, consent manager, and breaches, it'll self-explanatory. We'll just touch upon it in the respective sections. I just hand it over to Valerie to go over the obligations.
Thanks, Sarvesh. So for my section, I'll be referring to data fiduciaries as entities for ease of talking. Now, this section starts off by explaining the grounds based on which data will be processed. What it says is basically that entities can process a user's personal data for a lawful purpose, which is any purpose that is not explicitly forbidden by law, provided that the user has given their consent for the use and processing, or the processing is justified under certain legitimate uses. Now, what are these uses? Under this act, there are around 8 situations where they have the government has explained when they don't require asking the consent of the user, so they can process the data without consent. So for example, if you see in situation 1, it talks about data that is voluntarily provided or which is not explicitly denied. So let's say, for example, you go to a cafe and you know that the cafe records facial data via CCTVs. Now, as per this act, unless you go up to the counter and say, hey, I don't want my facial data used by you guys, the cafe is free to use that data as they want. Another situation that they have mentioned here is the second situation, where suppose a government department feels that they want to process your data or use your data to give you certain subsidies, benefits, licenses, whatever, then they can do so without asking you for consent. Now, what kind of subsidies, benefits, service? It is under the as may be prescribed provisions, which means that the rules around this will be made later on. But another contention with this act, when it was being seen at the Rajya Sabha level or even at the Lok Sabha level, the MPs argued that certain data which may be under digitized form or non-digitized form, it needs the approval of the central government for processing. So some of the state government MPs had raised contention to this, saying that state government should also have equal power in this respect. But right now, as the act is, that is not so. You only have to get the approval of the central government. Other situations are listed over here: state instrumentalities, obligations under law, court orders, and medical emergencies. And in the 7th and 8th situation, you can see disasters in case of disasters or breakdown of public order. Now, at least for disasters, the act says that you can refer to the Disaster Management Act of 2005 and refer to the definition there to understand what a disaster is. But we don't really know what public order is. There is no definition as such. So is a farmer struggle a form of breakdown of public order? We don't know. And also for employment purposes. Now, some of you may feel that you have heard of these situations somewhere before. That is because last year, the DPDP bill had a provision called deemed consent. The same, more or less the same situations were mentioned in deemed consent, but it can be argued that legitimate uses is more of an improvement, because certain situations such as the legitimate interest of the entity, those kind of situations have been removed from legitimate uses. Similarly, there were some situations that talked about business purposes like mergers and acquisitions. Those have been moved from legitimate uses and they're now under exemptions. We'll talk about those later. But this is all that you need to understand for a preliminary understanding of legitimate uses. But when we come to consent, now the Act also explains the proper procedure for asking for consent. The first thing an entity needs to do is that they have to send an itemized notice to the user. And this notice primarily has to have three things. One, it needs to specify the data that will be used and processed. Two, it needs to give the specific purpose for which this data will be processed. And three, it needs to give the contact details of the relevant authority that a user can approach in case they have a grievance. Now, specific purpose especially is very important in this notice because it ensures purpose limitation. Still, once a user does give their consent, entities are free to continue processing the data as long as the user does not go up and say, I withdraw my consent for the processing of this data. Some of the details of this notice are still yet to be specified and chalked out in the rules. But oddly enough, in this act, for some reason, the right to withdraw consent is only mentioned in this section of consent provisions. It ideally should have been mentioned in individual rights and duties. Nonetheless, the fact that it is mentioned at least specifies that the Act acknowledges the right to withdraw consent for the user. Now, what it has also introduced is this concept of a consent manager. What a consent manager is basically a person who acts as a gopher between the user and the entity. So anytime a user wants to give their data, withdraw their data, review their data, they can do so via a consent manager who is accountable to the user. That being said, the obligations, the technical, operational conditions, financial conditions are going to be specified later on in the rules. So we don't really know what is happening over here in terms of consent manager. What we do know is that the concept of a consent manager is still voluntary because it mentions the term consent manager may be used. Aside from this,
So Vadari, just on consent managers, can there be a situation where a consent manager can be made mandatory? And one of the things that I've been wondering about is that, let's say, MediaNama has a login, and therefore, and people sign up to read MediaNama stories behind the paywall, and then effectively we take their consent for, you know, accessing MediaNama. There is data processing, even if it's anonymized, that happens in the back end. Now, will it be required that we will shift our login or integrate through an API our login with government-approved third-party consent manager where a user can manage consent? And then when you expand it, will it mean that, if there are 7,000 sites that I may have signed up on over a period of time, will each of those instances of my giving consent be a part of this entire mechanism? Like, how does this work? Where does what is voluntary, what is not? Will all consent have to be routed through a consent manager? How does this work?
so right now, a lot of the obligations and functions of the consent manager are under as may be prescribed. We don't really know under what situations a consent manager is required and under what situations a consent manager may be a voluntary option. What we do know is that this is a space that we'll need to keep a lookout for, because most of the functions and duties, as I said, and description, you can say, are still under as may be prescribed section. So we don't really know what's going to happen over here. Right now, what the letter of the act does not use any mandatory term to imply that a consent manager is definitely required for every entity.
So the other thing that a consent manager has been brought in the same framework that account aggregator for financial services, which may be used for loans or even for sharing healthcare data with insurance companies. So a consent manager, so when someone signs up for a consent manager, they may also be, as a data controller, like entity, as you're saying, may also be required to share data to that consent manager with third parties. That could also happen.
It could happen. There are no specifications as yet. The decision, as far as I understand, of whether data will be shared with whom is with the entity. In certain situations, they may have to share data with someone called a data processor, but there is no mention of what they have to do with the consent manager.
Okay, so the entire framework for consent manager and whether we will have, let's say, a nationwide consent manager that is linked to a social credit system is yet to be described.
Yes.
Not a proposition I'm looking forward to, but okay. Thanks.
Okay. So, like Nikhil pointed out, there is a lot of ambiguity here around consent managers, but one specification, one clarity that we do have is a classification of certain entities. They are called significant data fiduciaries in the Act. I'll call them significant entities. So the Act says that there are certain criteria that need to be met for a data fiduciary or an entity to become a significant entity. Some of these criteria have been listed over here. Now, some conversations with media persons, ministers, Ashwini Vaishnaw and Rajiv Chandrasekhar have mentioned that this is not the complete list of criteria that will determine whether something is significant or not significant. These are more of suggestions to give you a certain idea of what kind of criteria will be there. But even there is some confusion. Like, for example, in the first criteria, you see volume and sensitivity of personal data. Now, there is no definition of sensitivity or sensitive personal data under this act. So we don't know how they're going to use or define this criteria. That will need to be seen later on. There is no as may be prescribed under this criteria, at least. So the reason to classify these significant data fiduciaries separately is because they will have special obligations. So they will have to, for example, appoint a data protection officer. They will have to appoint an independent data auditor. They will have to carry out data protection impact assessments. and other measures that the government will again specify later on. So this is again something that we will need to keep a lookout for. In general,
So just to jump in, sorry, just for context, the IT rules already have a definition of what is a significant social media intermediary. And the criteria there is that the SSMI should be an entity which has 5 million or more registered users. So as you can imagine, 5 million is a very small threshold in India. And a large number of entities that where someone may have signed up as a registered user at some point in time will then get covered under this if 5 million is a threshold. Secondly, that 5 million threshold was basically copied in the IT rules, was copy pasted um, from Germany's NetzDG law. And in Germany, 5 million is a fairly large number. In India, 5 million is a tiny number. So just for context, in terms of what our government is doing with a significant number of users, at least in IT rules, it's just 5 million.
Right. Okay. Thank you. So yeah, these are all the obligations of significant entities. That being said, every entity also has certain basic obligations that they need to satisfy. For example, they have to ensure that data is accurate, complete, consistent, especially if the data is going to be used to make a decision that is going to affect the user. Another thing that is a entity's responsibility is to make sure that consent, once withdrawn, is erased by both them and by the data processor that they appoint. The only issue over here is that in previous bills, they used to have a specific time frame, like say within 30 days, you have to erase the data. Now there is no specification as such. They have just mentioned it that it will be determined later on what this time frame will be. There are also some specific obligations for entities. For example, it is their duty to ensure there are certain security safeguards to make sure that there is no breach of personal data. Again, in the older versions, in 21 and earlier versions, these safeguards were much more detailed. They explained what kind of measures should be taken, but that has not been clarified over here. Still, if a personal data breach does happen, it's the entities or the data processor's responsibility to send a notice to the board, the data protection board, and the affected user to let them know that this has happened. If they fail to ensure security safeguards, they will face a fine of up to around rupees 250 crores. If they fail to inform the board or the user, they will face a fee of around 200 crores, if I'm not wrong. Again, a small issue over here is that the affected user has no way to get any compensation. There are no provisions on compensation over. And finally, there are obligations for grievance redressal. Now, again, if a user is aggrieved, it is the entity's responsibility to make sure that there is a mechanism in place for grievance redressal. Earlier versions like the 2018 version had again a set time limit. By this time you have to respond. By this time the complaint needs to be resolved. 2019 version allowed the user to approach the then data protection authority, what we now call the board. All of these provisions have now been removed. And along with that, a few more things that have been removed are, like I mentioned, sensitive personal data. The definition has been removed. So for certain data sets, like say health data, this might create a problem. There is no definition of harms. Now, this issue was raised both in the Lok Sabha and the Rajya Sabha, where MPs had mentioned that harms, unless you define what harms are, it cannot be understood by an entity what the consequences are. And therefore, they can't figure out what the compensations should be to give to the user. At the time, Union Minister Ashwini Vaishnaw had suggested that entities can look at the definition of loss under this act to derive the definition of harms. The only problem is that harms does not simply refer to financial losses. There can be a reputational harm, there can be a societal harm. So in that respect, we still don't know how compensation is going to be figured out. Other provisions that used to be there in the older versions, like say privacy by design or transparency provisions that ensured that the method in which data is processed is fair and correct, those provisions have now been removed. So this is what the final act looks like in terms of obligations to entities. Next, Saraswati is going to talk about individual rights and duties.
Hi, thanks, Valerie. Sarvesh, could you please move to the first slide? Yeah. So, firstly, the DPDP Act provides individuals with the right to obtain information about why and what part of their personal data is being processed and by whom. So, an individual can put in a request with a data collecting entity or a data fiduciary. Simply put, companies like Amazon, Google, Reliance, or even financial institutions like banks, insurance companies, etc., to provide them with a summary of personal data that is being processed. And but the act does not really specify what this summary would entail. Like it says that they have to provide a description of this personal data, but what would it actually contain? There's no specifications about that in the act. Secondly, data collecting entities.
Saraswati, hi. So
Yeah.
I think one of the things we need to keep in mind over here is that under the EU GDPR, people have been able to ask for all of their data. So I remember reading about how someone got like 14 odd GB of data of their data from Meta upon request, right? So I think the Indian government sort of sidestepped this issue by saying you'll be provided with a summary of what's being processed.
Summary of
But they still haven't defined what a summary is. So will it be a 2-line summary or will it be a 3-page summary? What will it be? We have no idea. It's almost like they're just avoiding giving all data.
Yes,
The other
that's
thing to keep in mind.
something that's not.
The other
Yeah.
thing to keep in mind, and I don't know if you're covering this later, but is that one of the things that that you can do once you know what all data is there, and it was being considered in previous versions of the bill, was you could port your data. Now you're just getting a summary and you can't even port your data from one service to another.
Right.
Go ahead.
May I continue? So yeah, data fiduciaries, along with this summary of personal data fiduciaries also have to provide an overview of the processing activities that is being undertaken with the personal data of that particular individual. And individuals can also ask them to provide identity of all the third-party data processors and data fiduciaries with whom the data fiduciary, primary data collecting entity, has shared the personal data with. For example, if there's an individual who's using a telemedicine service through an app, they can ask the operator to send in a list of all the third-party sources, for example, for pharmaceutical agencies or even hospitals with whom the primary data collecting entity or the app operator has shared the data with. Next slide, please. Secondly, individuals can also request entities to correct their inaccurate or misleading personal data in their records and fill up any incomplete personal data, also update the personal data wherever required. And most importantly, individuals have the right to request erasure of their personal data if the purpose for which the data was collected has been fulfilled. For example, if an individual has registered for an online educational course and they've completed the course and have also received all the certifications with respect to it, they can ask the platform to erase all their personal data so as to avoid getting their personal data used for advertising or marketing purposes. But the manner in which this request for information as well as erasure of personal data has to be exercised, this is something that's not defined and it will be defined under the rules later. Next slide. So primarily we've talked about two rights: right to information on personal data and right to request for erasure. There are certain limitations to these rights. Firstly, even if we are exercising our right to information on personal data, we won't have a complete picture of how third-party processes are processing our data, because under these provisions, third-party processes are not mandated to provide an overview of the processing activities that are being undertaken, while the primary data collecting entity has to provide that information. So there's this distinction there. And also, information on personal data cannot be obtained if your personal data has been shared by your data fiduciary with the law enforcement agencies for the purpose of prevention, detection, or even investigation of offenses and cyber incidents. Now,
Saraswati, sorry, I just want to go back
yeah.
to processing of personal data.
Hmm.
Let's say at MediaNama, we have, let's say, WooCommerce that we use for processing our transactions. And so therefore, that data is shared with WooCommerce. Now, WooCommerce might be hosted on AWS. And then,
Yeah.
therefore, AWS would be WooCommerce's data processor, right? So, do I have to only give the first level of data, as in that our data might be processed by WooCommerce, which might be using other third parties, or do I have to go down to every level? Because every online company basically uses multiple services, and they typically have no clue on who's got which other entity that's going to be processing data. And in this case, I guess the definition of the word processing might also be worth looking at. But it's like if you go down to like level 0, there would be thousands of data processors for each instance or each company.
Right.
Because every company will have someone else who's processing something, who will have someone else who's processing something, and then and so on and so on.
Branches of it. Yeah.
So where does this end?
Right. So, from what we can understand, and Sarvesh had pointed out this to me, that the provision mentions the said data fiduciary, said data fiduciary in the sense the primary data fiduciary. It's a first layer data fiduciary and the third party sources associated with that particular entity. The first layer, basically. That's what we've understood.
Okay, thanks.
Yeah, so I was talking about how the personal data can be shared with law enforcement agencies for prevention and investigation of offenses and cyber incidents. This can be termed as reasonable for when it comes to investigation of offenses, but like Shivangi Narayan had pointed out to me that it can be misused when it comes to because the definition of crime investigation in itself is very broad, and data can be manipulated in order to fit into any kind of investigation, which may potentially lead to selective targeting of specific communities without them having any recourse for correction or any remedial measures, basically. So that's one of the things that is concerning about this provision. Then the scope of right to erasure also appears to be reduced. This is because personal data can be erased only when it is no longer needed for the purpose for which the consent was obtained. But there can be cases where the consent is not explicitly obtained. I mean, if the individual has not given their consent explicitly, then the, like the, they cannot exercise their right to erasure, basically. This can also happen in cases where the government is processing the data and then you cannot exercise your right to erasure. Like your data cannot be erased if the government is using it for purposes that's listed under legitimate use cases.
So this is
Then
also the
retention can also
AI
retention of data
clause.
can
Sorry, this is also the AI clause one. One part, and I think we
use
might
of
get
public
into
data.
this later, is that public data can be processed without consent. If personal information shared in the public domain can be processed without consent, and then add to that this particular clause, which says that, which basically reduces the scope of right to erasure by saying that only that data for which consent has been obtained be removed. So once your data is out in the wild, and someone may be processing it, training their LLMs and their algorithm, like as a part of the LLMs training, and then it can also be you can't ask for it to be erased. The privacy rights related to public information are basically dispensed with the. Sorry, Vadadi, carry on. Sorry, Saraswati.
Yeah. Yeah, so data can be retained and it cannot be erased if the data fiduciary has to comply with any existing law. law, which states that data fiduciaries have to taxation or audit purposes, can be anything, be able to exercise their right to erasure. Hello, am I audible?
Yeah, now you are. We lost you for a bit.
There was a
Yeah, I just want to go to the last point again about the legal purpose.
yes. So data can be retained if data fiduciaries have to comply with any existing law. For example, if there's an RBI law which states that payments data have to be retained for so and so period for purposes of taxation or any other financial objectives, then individuals will not be able to exercise their right to erasure because the data fiduciary is bound by that law and the data will have to be retained for so and so period as it is prescribed by the said law. Next slide. Yeah, individuals are like also have the uh, uh, must have an easy and accessible mechanism to register any grievances or if they have any complaints with the data fiduciary or if they're not able to exercise their rights easily. If they do not receive any satisfactory response with the data fiduciary or the data collecting entity, they can escalate that complaint with the data protection board, but there's no time frame within which the data fiduciary has to address an individual's grievances. Uh, this will be prescribed under the rules later. Then right to nominate essentially relates to the data rights of deceased persons. One has the right to nominate anyone to exercise their privacy rights in case of death or incapacity. The process for this nomination will be defined under the rules later. Incapacity here means unsoundness of mind or infirmity of body. Next. In order to exercise our rights, there are certain duties that users have to keep in mind. One of them is refraining from registering a false or frivolous grievance or complaint. They have not defined what false or frivolous grievance would mean, and this can prove to be a discouraging factor for many users who would actually wish to go and register a complaint, but would be apprehensive about whether if their complaint would be dismissed as false or frivolous, and then that they could even attract a penalty of at least 10,000 rupees. So that's one problematic aspect here. Then impersonation is prohibited. Suppression of any material information in cases where people have to apply for an identity card with the government, or even if they have to access any government scheme, benefit, or other welfare activities. They are not allowed to suppress any material information. But as Lalit Panda had pointed out to me, that people should have the space to preserve any material information for the sake of privacy and only provide what is necessary for that particular objective, which is not guaranteed here. Then furnishing information which is authentic and verified is a condition for exercising right to correction and right to erasure. This may be understood in terms of right to correction, but how will this apply to right to erasure and will it further restrict the scope of right to erasure is something that needs to be considered. Next slide. So yeah, definitely the data protection bill provides certain rights, but with a lot of limitations and conditions, and which can potentially obstruct an individual's right to exercise these provisions freely or even in the way it should be. Previously, the previous versions of the bill provided more in terms of rights with respect to right to be forgotten, which basically enabled individuals to ask a data fiduciary to stop their data from being disclosed under certain conditions. Then they also had right to data portability, where individuals could transfer personal data from one company to another. Again, there were technical conditions for it. Then we had right to confirmation and access, which essentially provided individuals with a mechanism to seek confirmation on whether their personal data is being processed, and this information had to be provided in a clear, concise manner, all in one place, in a manner that is easily comprehensible to the individual. So that's an overview of the rights and duties that have been mentioned in the bill. Next, we move on to the provisions concerning processing of children's data, and Kamya would take it over from here. Thank you.
Thanks, Saraswati. So, the Digital Personal Data Protection Act. Am I audible? Just want to check before I start talking.
Loud and clear.
Okay. So, the Digital Personal Data Protection Act defines anyone under the age of 18 as a child. This is despite the fact that experts had been urging for a graded approach. So, essentially, what they were asking for was that people between the ages of 13 to 16 should be treated differently than those below the age of 13. However, currently, the way the act is structured, everyone starting from 1 to 17 would be treated the same. And anyone who's classified as a child, companies must ask their parents or guardians for verifiable consent before processing their data. This provision for verifiable consent was also present in the 2022 iteration of the bill. And experts at the time had said that to get this verifiable consent would imply anything from the use of facial recognition software to the submission of government documents. And of course, we must note that to verify who is a child, you have to know the age of every single person using the internet, meaning that everyone has to go through verification. This can make it potentially impossible for people to be anonymous online and can threaten the freedom of expression of activists, whistleblowers, and journalists. Further, let's assume that a parent gives consent to their child to access a certain website. What happens when that child encounters problematic content on said website afterwards? Platforms will no longer be held liable since they did their job and got parental consent. But in such a scenario, did the consent actually accomplish the task of keeping a child safe online? Next, just like Valerie had previously pointed out, the Act notably lacks the word harm. And with respect to children's data, it says that companies must prevent the processing of any data that has detrimental effects to the well-being of a child. What is missing here is what detrimental effects means. The 2022 version of the data protection bill asked companies to conduct data processing that is not conduct data processing that is likely to cause harm to a child. There, they had defined harm as bodily harm, distortion or theft of identity, harassment, or prevention of gain and causation of loss. The current version doesn't have any such distinctions. How this will affect a child and their guardian's ability to go up to authorities and claim that they have been adversely affected by a data collection activity is unclear. Specifically, in cases where harm isn't physical in nature. The Act prevents websites from engaging in tracking or behavioral monitoring of a child. However, certain companies will be exempt from this if the central government believes that they are processing the data in a verifiably safe manner. And this exemption only applies to a certain age group. So it's important here that we note that this approach to doing things is whitelisting. Effectively, you're giving children access to only a certain number of websites instead of giving them free access to the internet. I spoke to Nikhil Iyer at the Quantum Hub about this topic, and he had flagged that this could lead to a problem where if a platform wants to make advancements of any kind, even if they are for the safety of a child, they might have to go back to the government again and again to seek their approval. This will effectively kill off any innovation. He had also mentioned that instead of this phrase, detrimental effects to the well-being of a child, if the Act had asked platforms to meet the best interests of a child, companies would have had an incentive to create better platforms. However, with things the way they are right now, this wouldn't end up happening. It's important to flag here that how this whitelisting approach will work will be prescribed under rules that will be created for the Data Protection Act. Similarly, how verifiable parental consent will be obtained will also be prescribed under the rules. If companies fail to meet the requirements set for children's data, it can result in a fine of rupees 200 crore. And now I'll pass it on to Aarti. We'll discuss the data protection board.
Hi everyone. Is my audio fine?
Yeah.
Okay, great. So thank you so much for that, Kamya. The Data Protection Board of India was first proposed in the 2022 version of the law, and it remains in the 2023 version of the law as the penultimate body, essentially investigating non-compliance with the act and then penalizing it as well. Like last year, it's designed to be a digital body, and it's also supposed to be an independent body. And we'll touch upon why that might not necessarily be the case a little later on. As for what it essentially does, it essentially addresses complaints by different kinds of stakeholders, including data principals. Now, those complaints by data principals could be on a variety of things, including data breaches, data fiduciaries and consent managers breaching their protection obligations under the Act, or even complaints by data principals on the exercising of their own rights under the Act that Saraswati just touched on. The board can also respond to references from governments or courts. Now, those governments could be state governments or the center itself. And interestingly, it can also respond to references from the Indian government on intermediaries breaching blocking orders that the government is empowered to issue under the Digital Personal Data Protection Act as well. And we'll touch upon those orders a little later on in the presentation. And finally, Valerie had mentioned that consent managers have to register with the board. So the board can also take action and respond when intimated of consent managers breaching their registration conditions as well. As for who will be doing all of this execution and performing all of these functions, what we do know is that the board will be composed by a chairperson and various members, and these will all be deemed to be public servants. And broadly speaking, they should have experience in data governance, in implementing laws related to consumer protection, ICT, digital economy, or any other field that the government thinks, central government thinks might be useful to the board's functioning. We also know that one of these members should be a legal expert as well. Now, what's concerning over here, and coming back to the independence point, is that everyone, including the members, the board chair, they're to be directly appointed by the Indian government. Now, the number of members, the manner of appointment as well, all of these are currently unprescribed in the bill. So similar to last year, we kind of have these concerns being raised again over the independence of the board and whether a government-appointed body can essentially be expected to be a fair arbiter for the entire country. So that's a little bit on the composition of who will be performing all these functions. As for what these people can do, what powers they have, the board has various sorts of powers. The first and the most obvious one is directing urgent remedial measures during personal data breaches, so just to kind of stem the immediate tide. Apart from that, in the ordinary course of events, of course, it can receive complaints of different kinds. There are two approaches here. One is the board at this stage can either decide to order mediation if it feels that, a full-fledged investigation is unnecessary, or it can choose to initiate a full-fledged investigation by authorizing proceedings. The board, while it's conducting this investigation and inquiry, is empowered with the same powers as a civil court. So it can call for people, evidence, and all of that. And it can also requisition support from different kinds of officers. So those could be police officers, government officers, including state or central. And those officers are bound to comply with those requisition requests. And naturally, the outcome of an investigation would essentially be the board's decision. And now there are three, broadly speaking, types of decisions the board can take. One is simply just closing the complaint if the violation is found to be insignificant. Another is if at any stage the board finds that the complaint is frivolous or, for lack of a better word, silly, it can close the complaint and also impose costs if necessary. And finally, if the board finds that the violation is significant, it can continue to impose a penalty. Now, this will be discussed later on in the call, so I'm not going to go into it into too much detail, but penalties are decided based on a variety of factors. That includes the gravity of the breach, the type of the data affected, and also the proportionality of the breach. So whether it sort of matches up, whether the fine matches up to the gravity of what happened in that sense. So those are broadly speaking some of the powers that the board has. And these powers also intersect with the government's powers, the central government's powers under the Act, which are vast, as we've discussed already. So, for example, the government has powers under the Act to require the board or any other entities as well to furnish any information that it calls for. And another interesting power, which we referred to earlier, was essentially a blocking provision. So the government can block, public access to information in the interests of the general public. And for that to happen, it should receive two types of notices. One from the board, essentially informing it of repeat offenders, people who've been penalized with financial penalties over 2 times. And the other, where the board essentially advises blocking access to information that's transmitted on resources that enable that fiduciary or entity to offer goods and services in India. So the ability to block is very tightly controlled or sort of intersects with this government-appointed data protection board as well. Now, as for the jurisdiction or the remit of the board's functions, what we kind of understand over here is that it does seem to have a kind of exclusive jurisdiction over the matters that it's empowered to adjudicate on. So, for example, civil courts are restricted from entertaining suits on matters that the board is empowered to decide on under the Digital Personal Data Protection Act. We also see in general that neither courts nor authorities can grant injunctions or interim orders against actions.
Sorry, Aarti, we can't hear you clearly.
In pursuit of power with the Act, yes, the board's work as well. And since here we okay, 1 second. Is it a little better now?
Yeah.
Yeah. Okay. So where should I start off from?
I think the second point of it.
Okay, thank you. So we also see that under the Act in general, injunctions can't be granted by courts or authorities on actions taken in pursuit of powers under the law itself. So we can perhaps have to assume that this could extend to the Data Protection Board as well. And similar to last year, we also see that suits can't be brought against the good faith actions taken by the board. And its actions cannot be invalidated by certain conditions, whether that's vacancies or defects in the member's appointment or constitution, or even procedural irregularities that don't necessarily affect a case's merit. So that's just a remit of what the board's powers are. Could you just, sorry, 1 second. But this doesn't necessarily mean that the board's orders are penultimate. There is a scope for them to be challenged. So one way that can happen is on request, the board from one of the parties, the board can modify, suspend, withdraw, or cancel the orders that it's issued. Another approach is aggrieved persons can essentially approach the Telecom Dispute Settlement and Appellate Tribunal, and this is set up under the TRI Act. And I believe it's also empowered, it's also the Appellate Tribunal for complaints under the IT Act and an Aviation Act. So appeals receiving the, and the tribunal has the power to either confirm, modify, or simply set aside whatever the board has said. Now, these orders are also treated as if they're civil decrees, and they can actually be transferred to civil courts which have local jurisdiction and be executed by them as if it was their own order as well. And if you're still unsatisfied with what the tribunal has said, the penultimate appeal can be made before the Supreme Court of India. And the TRI Act has all the provisions for how that process would actually work out. Sarvesh, could you just change the slide, please? Now, in terms of how this is different from other regulators, in the 2018, 2019, and 2021 versions of the bill, we didn't actually see a Data Protection Board of India. We saw a Data Protection Authority. And we've covered this extensively on MediaNama as well. That authority had a wide range of functions. They ranged from advisory to rulemaking to vigilance to addressing personal data breaches. It was a very long list. And that's actually been trimmed down quite significantly. You could call it a devolution. What we see now is the Data Protection Board is essentially only responsible for investigating and consequently penalizing non-compliance with the Act. A lot of those extra things have kind of been removed. Another thing is that's starkly different is actually the lack of procedures, which also feeds into the concerns over independence. These are the consequences or a side effect of a law that leaves so much to be prescribed. We have very little insight on, the appointment of members. We have very little clarity that or confirmation that, the most independent route will be taken. So I think a constant concern has been, will the board succumb to pressure from the government or the executive that appointed it? And that's something we can really only know moving forward as well.
But just for the context, one of the things that we, the conversation at MediaNama every year, we have conversations with data protection commissioners of various countries. And we had this really long chat, right, almost like a 2-hour conversation with Libero of the Philippines. And the first act of the Philippines Data Protection Commission was actually to take their election commission, like to take on the election commission, because there had been, breach of election data in the Philippines, not once but twice. And Chairman Libero and go to our YouTube channel and that conversation, that video is still there. Chairman Libero talked about how the commission wanted to point out and send a signal that nobody is beyond the jurisdiction of the commission and they will act and use it. So they took on, like he literally said that at that point in time they didn't even have an office, they were operating out of a Starbucks. And they first case against the election commission there. So, the board will largely toothless. Sorry.
No, thanks for that, Nikhil. I'm going to be keeping my video off just to preserve the bandwidth. So that was just a general roundup of the Data Protection Board of India. And now we'll be transitioning into a section on cross-border data flows or transferring data outside of India, as the bill puts it. Now, this was an easy section to report on because there wasn't much to say. What the Act does say essentially is that personal data transfers are allowed to countries unless those are countries restricted by the Indian government. And it's not specific about the conditions or processes for what those restrictions might be. Now, this is somewhat of a 180 from what we saw in 2022, where essentially the government only allowed transfers to countries that it's approved. And that sort of raised a lot of concerns over, regulatory backlog and businesses being impacted as well. So this is a departure from that. Another concern was essentially how these provisions would interact with sectoral regulations, and the bill does answer that to some extent. It says that the provisions on cross-border data flows will not conflict with prevailing Indian laws that have higher protections or restrictions on personal data transfers outside of India. And we've assumed or sort of inferred that means data localization proposals put forth by regulators like SEBI and the RBI will continue operating as is and won't necessarily be in conflict with the Act as well. But again, over here, just to point out, what's different from the previous bills over here is that there's no actual demarcation for sensitive data and critical personal data. So cross-border, sorry, Nihal, were you saying something? Okay. So there's no actual demarcation of sensitive or critical personal data abroad. And we saw this in the 2018, 2019, and 2021 versions of the bill, where increasingly sensitive data was subjected to increasingly restrictive provisions on their transfer abroad. So how this will actually pan out, how data will be secured, even if it's extremely sensitive, remains to be seen. And once again, such a short provision leaves more questions than it leaves answers. And some of the questions that I'd like to leave you with on this provision that we can take up later, maybe as well, include on what basis will countries be restricted and by when? Is this list indefinite? That is, once a country is added to a sort of blacklist, can it ever be taken off? On the flip side, can a country that's considered good by the Indian government, can it suddenly be considered bad? And then what's the basis for that? Can countries appeal the blacklist status? Is there a possibility for that? And aside from that sort of no conflict provision that I mentioned earlier, can we assume that data localization still may be on the cards in some form, given that so much is left to be prescribed in the bill? And interestingly, there's also a bunch of exemptions that are mentioned under the bill, which Sarvesh will be covering later. But one of them, I think Nikhil also found particularly interesting in this section specifically, is that this section, the law's provisions are essentially exempted in cases where the data processing is of data principles that are outside of India and is processed pursuant to a contract entered into by that person with a person based in India. And I think Nikhil's question was, could this precipitate a sort of Max Schrems-like challenge against cross-border data flows happening between the EU and India, or any other jurisdiction and India for that matter? So maybe Nikhil would like to come in here and just sort of share his
No,
thoughts.
I have more questions than answers here, but one other little fact that I can point out is that when this data protection bill came out, there was a fairly undiplomatic statement from Ralph Sauer, who was there at I think the last MediaNama conference that we'd done, and he was representing the EU on adequacy of the data protection bill. Ralph was in India in December last year. I met him, and he put out a tweet saying that this is probably the weakest data protection law that he's seen. And one was quite surprised until one found out that Ralph is no longer looking at data adequacy with India, but this is more out of academic interest. So, one of the questions that I had is that, and I mentioned it to Aarti and the team as well, that, Max Schrems is famous for essentially the restrictions on data transfers between the EU and the US, because he went and filed a case saying that his data is not as secure in the US as it is in the EU. And so therefore, data transfers between EU and the US should not be allowed. So, if data principles are beyond the scope of data principles who are not Indians are beyond the scope of this bill, what data protection rights do they have in India? And so therefore, can there be a case that there isn't sufficient adequacy between the EU and India? And some of these are one mechanism that the EU has explored as these standard contractual clauses. Honestly, I don't know much about them, but it's unlikely that a standard contractual clause will prevent, let's say, a government body from or a police from accessing data of anyone, including people who are not Indian citizens. So we don't know how this is going to play out. I don't know if anyone has any thoughts on this, but we'll keep this for a conversation for when we're done with the initial part of the presentation. Aarti?
All right, thank you, Nikhil. So yeah, that's essentially it about cross-border data flows. And up next, we have Valerie speaking on the amendments to the Right to Information Act included in the data protection law.
Thanks, Aditi. So right at the end of the Data Protection Act, in the miscellaneous section, we have this amendment to the RTI. It specifically refers to section 81J of the RTI. So what is this section? It's basically an exemption to the RTI, where it says that if certain information is considered to be personal information and it has no relationship to any public activity or interest, then the public information officer is not obligated to share this information. And within this section itself, there is a unless and until section over here that says that, say, a central or state level public information officer or an appellate authority feels that the larger public interest justifies the disclosure issue, then the information can still be given. Along with that, there is another one-liner clause right after 81J that says that any information that cannot be denied to the parliament or a state legislature cannot be denied to any citizen of India either. Now, what the amendment does is that it takes this section 81J and the one-liner after it and replaces all of this with just information which relates to personal information. Now, this has broad-scaping impact on the RTI. So we talked, or rather we talked and received comments from Shailesh Gandhi, who is the ex-Central Information Commissioner, who talked about why and how this amendment is going to have broad-scaping impact, as I said. First of all, the fact that the one-liner from this section has been, this proviso clause, what is called, has been removed, means that citizens have now lost the right to access the same information that the parliament or state legislature had access to. Why is this important? As Shailesh Gandhi had explained, this line had served as an acid test of sorts to check whether information is truly personal or not. So, for example, suppose you file an RTI and the information officer says that I can't share this information, it's personal information. If that one-liner had stayed, what that information officer would have had to do is they would have to make a statement, I won't share this information even with the parliament, which would have proved the acid test that this information is personal information. But that has been removed now. So essentially what this amendment has done is it has given a right to deny to public information officers. Now, as journalists, we have often filed a lot of RTIs over the years. And most often, the most common excuse we get for non-disclosure of information is that this information is confidential, this information is personal, we cannot share it. But it was, according to Gandhi, it was still considered an illegal move because there is a section, as I mentioned, where a central or state level officer can say that this exemption can be overridden. But now the amendment has of sorts given a right to the public information officers to not disclose data. Another issue is what is personal information. So like I said, the one-liner used to act as the acid test to show whether something is personal information. Now what do? Do we assume that personal information is the same as personal data that is defined in this act? Or do we look at the word person itself and then what does person refer to? Does person refer to the definition given under the data protection law? Or is it the person that is understood by the RTI Act itself? Also remember that RTIs are often not only filed for specific people, it's done for welfare programs as well. So again, some examples that Gandhi had given was, say, the MLA funds or the PM fund. You can file RTIs asking for this information, but now depending on how personal information is going to be interpreted, and this is not under an as may be prescribed section, depending on how personal information will be interpreted, it is going to complicate a person accessing this information of how certain funds have been used. So this is going to create a hindrance in the transparency process. You can, one good thing is, maybe like you can consider it a good thing, is that right after section 81J, there is section 82, which reiterates what the section had said in terms of if the larger public interest justifies the disclosure issue, then the information can be shared under the RTI request. But the difference is that 82 does not mention to whom you can go to challenge this exemption. In 81J, you could see that there was the central or state level officer or the appellate authority who would decide whether or not it is justified or not. But now we don't know where to go. Do we go to the Data Protection Board? Do we go to the appellate authority mentioned in the RTI Act? We don't know. Also, in 2012, there was a Justice A.P. Shah committee report that had said, that had looked at various laws from a privacy principles perspective. And it had stated that the Privacy Act cannot circumscribe the Right to Information Act. So it was already decided back then that just because you say that something is private or personal information, you can't override the RTI. But how the amendment is going to be done now, it seems that it can. So it's overriding what was decided beforehand. And lastly, a question that Gandhi MPs and multiple experts have asked again and again is, why is this RTI amendment being introduced in a Data Protection Act itself? Chandrasekhar and even Vaishnav have at times said that this is because you're referring to personal data. But if that was so, you could have just stuck to section 81J, the one-liner after section 81J that mentioned that any information that cannot be denied to the parliament cannot be denied to the citizen was also interpreted to apply to the entirety of the RTI Act. But now even that has been removed. So these are some of the larger contentions that have been raised so far. After that, we are now going to look at government powers and exemptions. Sarvesh will cover this section.
Yeah, just to add to this, we actually, I think at one point in time, we were filing some 30-40 RTIs a month. And almost all of our RTIs tend to get rejected for some reason or the other, which frankly they shouldn't be. And we've been seeing a dilution, and just the entire process of trying to get the government to information officers to respond to RTIs has become extremely tedious, and and very disheartening. It's one of the reasons why we started that unanswered questions newsletter, because we wanted to highlight that these are the types of questions that we are asking via RTI, and that they are actually being rejected for no reasonable reason as such. But we're seeing this a lot now. I think with this particular provision coming in, I'm expecting that will be even more difficult for us to get responses to right to information requests. Sarvesh.
Yeah, thanks, Nikhil. So the last big section in the Act is the powers that the government has. They have a broad range of powers, but the most controversial and one of the most the largest powers they have is that they can exempt any instrumentality of the state from the Act, from any provisions of the Act, in the interest of security of state, sovereignty, and integrity of India, and the very broad clause of maintenance of public order. We've seen how these reasons have been used in Section 69A blocking orders. They've been wielded freely, and they can now also be wielded freely under the Data Protection Act to exempt any government entity. What is an instrumentality is not defined in this act or in any other law, but it's been determined on a case by case basis in jurisprudence. So law enforcement agencies, state and central governments have been declared as instrumentalities of the government. Interestingly, even public sector companies, when the government share is over a certain percentage, are considered instrumentalities. Overall, it looks like while a citizen might have their right to privacy in front of a private entity, the same right to privacy is not guaranteed from the government because any of the government entities can be exempt. This is significantly, the final version, the Act is significantly diluted user rights over the previous iterations of the bill. For example, in 2018, when the Data Protection Bill was first introduced, it said that there has to be a law describing procedure in which government can access data for security reasons. Such a clause doesn't exist here. In 2019, the law said that there has to be procedures, safeguards, and an oversight mechanism. Again, that's missing from the Act. Now, added to this power to exempt any entity, The government also has the power to retain any personal data for an unlimited period of time. Users don't have the right to request erasure. They don't have the right to request correction or updating of their personal data. All these are rights that they have against private entities. They don't have these rights when it's the government doing something with the personal data. And this doesn't just apply to the exempted entities. This applies to all government entities. So basically, any government entity can store data for any period of time in any way it decides to. The government also has the power to demand information from companies and the Data Protection Board. It says that they have the powers to demand information for purposes of this act, but that's not exactly clear what are the purposes of this act that it can demand information from companies. Now you combine all of these powers. Basically, the criticism is that the government has powers to create uh, mass surveillance databases like NatGrid without any safeguards for a user's right to privacy or their personal data.
So just to give some context on NatGrid, I actually had gone through a couple of years ago all parliamentary disclosures on NatGrid, because NatGrid is otherwise exempt under the national security laws. In fact, the Software Freedom Law Center, I think about 10 years ago, had filed an RTI and got information on NatGrid, after which it was brought under a national security sort of clause and exempted from RTI. But at least there have been disclosures to Parliament on NatGrid, and so you will find on MediaNama like a comprehensive overview of what all was planned and what all is being executed. When it comes to NatGrid, one of the things I remember reading early on when the Congress government was moving on this was that initially there would be 21 public and private databases that would be providing information to NatGrid. So that included airline ticketing and airlines, and it included banks, etc., as well, which are private entities. Outside of that, the plan was that the phase 2 would be 900 plus public and private databases. And then I think the next phase 3 was supposed to be 1600 public and private databases. So one of the things that I look at when I look at this particular aspect of the bill, there's a phrase used in the West about privatization of surveillance, where private companies are essentially responsible for conducting surveillance activities for the government. What we are seeing over here is, because there is no restriction on government asking for data from companies for any individual, this is a new kind of privatization of surveillance, where every private company that is collecting your data, every app that you're using, is essentially collecting information about you that can be demanded by the government. So there is literally no restriction and no requirement for a court order as such for surveillance activities. And this also has to be seen in conjunction with the amendments to the criminal laws that were brought in all of a sudden in this last session of Parliament, which again enables search and seizure of digital devices. And Arthur published a fairly comprehensive post looking at what those 3 laws contain that have an impact on digital aspects. So you might want to take a look at that as well. Sarvesh?
Yeah. So the government also has the powers to make rules to carry out the act. So anywhere in the bill where in the act where it says as may be prescribed, so those are areas that the government can make rules for. And there's a list of about 27 items. I think we covered it throughout the presentation, but it's a long list, and a lot of things are unclear. The Data Protection Board, specifically the functions, the members, how it's going to be appointed, all of that is still unclear. Lastly, the government has the power to block access to information. Aarti covered this in her section also. So the Data Protection Board can advise the government to block data fiduciaries' content if that data fiduciary engaged in multiple offenses, or if it is in the general interest of the public, which is a very broad phrase. So this in fact gives the government more power to block content than the Section 69 blocking powers that the government already has in the IT Act, which is already controversial in itself. Apart from this, there are other exemptions as well. For example, the government can exempt a class of data fiduciaries. They've mentioned the word startup specifically there. They said that they can exempt startups from certain provisions. Uh, this will be through a notification issued later. There are also exemptions for certain use cases, law enforcement purposes, legal right or claim, judicial purposes, personal data of those outside India. So this essentially refers to data of foreign citizens that's being shared with Indian companies. So this data is now only going to be subject to regulations that exist in that country. The data does not have any protection under Indian law. This can again raise the question of adequacy with the EU, the point that Aarti had also brought up about a challenge like the mag shrimps in India happening. All that is likely because personal data of foreign citizens being processed in India only have to adhere to whatever contract that has been entered and not the provisions of this act. Lastly, mergers and amalgamations also are, when personal data is being processed for this reason, it's also exempt from the act. And debt recovery, this is an important one because the illustration in the act says that if someone defaults on their loan repayment, the financial institution can go after this person by processing their personal data without their consent. Now, if you look at what's been happening with digital lending apps, we already have an issue where many of these illegal apps are accessing contact lists of users, are accessing their photos, morphing their photos, and threatening, blackmailing users that if they don't pay back, that they're going to circulate these photos with their contact list. Given such a situation, it seems worrying that debt recovery is something that's exempt from this act, meaning the banks and financial institutions might be able to use personal data in any way they deem fit for recovery purposes, which is worrying. There's also an exemption for research and statistical purposes. There are more detailed guidelines that the government said that it will issue for this exemption. Penalties, we've covered it throughout little by little, but essentially when the Data Protection Board finds non-compliance and wishes to impose a penalty, the quantum of penalty is determined by a variety of factors, including the nature of the breach, the gravity of the breach, whether it was repetitive, what was the loss, what will be the impact of a penalty on the company, what action was taken by the companies to mitigate that non-compliance. But all of this is subject to a maximum penalty amount. So for different types of offenses, there's a different maximum amount. It ranges from 50 crores to 250 crores. 50 crores is the general for any breach in the act. But if it's more specific, such as failing to prevent data breaches, it's 250 crores. Failure to notify data principals of a data breach, it's 200 crores. Non-fulfillment of obligations when it comes to how the children's data was processed, that's 200 crores. And there's also a penalty for users, which has been criticized. So if users don't follow or if they don't perform their duties, which is not to provide materially incorrect information or file frivolous complaints. So all these, the user themselves can be fined up to 10,000. The government has the power to increase this amount to a maximum of 500 crores by amending the schedule later. Non-personal data is now is completely out of this act. It had a feature in the 2021 bill where back then the Joint Parliamentary Committee in their report, they explained that non-personal data also has a lot of privacy elements involved in it. So it is right to include non-personal data under the Data Protection Act. This was there was a debate going on about whether this is correct or not, and I think eventually it's now been settled by the government to exclude non-personal data from the Data Protection Act. But the important question here is what happens to non-personal data that is de-anonymized. We have many articles on our website about how it's easy to de-anonymize non-personal data when you layer multiple levels of non-personal data. It doesn't take rocket scientists to figure out who this data belongs to once you layer this information. But our thinking is that once the non-personal data is de-anonymized, it qualifies the definition of personal data, so it will fall under the ambit of this act. Concerns, we've talked about these throughout the presentation. Just to recap some of the important ones. the wide powers given to the government, which could lead to state surveillance of citizens, the broad blocking powers with the government, age thresholds, which reduces the access and agency of teenagers when they try to access the internet. The free pass to scrape publicly shared personal data. This must be particularly looked at from the context of AI companies. So AI companies basically can go about scraping personal data that's already shared publicly. There's no hindrance.
I'll give you one example.
Yeah.
Talked to Derek O'Brien about it, and he mentioned it in an article that he wrote, naming me as having told him that. But if you remember, 2020, there was this case where there's a company, Chinese company called Zenua Corp, that was profiling some 10,000 or 50,000 Indian citizens. And this was an Indian Express investigation and became quite controversial. So today, any company wants to build a profile based on publicly available personal information for the purposes of
Your voice is breaking. Can't hear you clearly.
Sorry, when I say anyone who wants to create personal, who wants to create a profile in citizens on the basis of their publicly available personal data can do that very easily because they're exempt. So Chinese surveillance, personal information of the web or Indian citizens can still do that. Another example is Clearview AI, which has been sued in the US and has lost cases because personal information was used to train facial recognition software without user consent. Companies like that are also exempt. So on the whole, if any information about you is public, it's so typically if you look at publicly available personal data, there are two things that are in that data. One is privacy rights because it's personal information. Just because it's public doesn't mean it's not. It shouldn't be protected under privacy. The other is copyright. So if let's say Surveys taken my photo and I will have privacy rights. Surveys will have copyright if he's taken that photo with consent. So it's still protected by copyright, which is why AI is going to become a very interesting case going forward. Sorry, I think my here. I'll jump in whenever else. Surveys, back to you.
Yeah. Yeah, that's about it. I think the data protection board not having independence, that's another big concern, because the data protection board is also tasked with investigating any non-compliance by the government. So for the data protection board to be appointed by the government, it raises questions of conflict of interest there. Lastly, looking at the timelines for the DPDP Act, the Act itself has been notified in the Gazette, but the date for when it will go into effect is yet to be notified. The government said that it's in talk with the stakeholders to determine the dates. But importantly, different entities will have different dates. The Act allows the government to provide a graded timeline for not only the different provisions, but also for different types of entities. From what we heard from Rajiv Chandrasekhar, big tech companies will be asked to comply first, followed by startups who might be given a longer timeline. Overall, Ashwini Vaishnav mentioned that the Act will be implemented in 6 to 10 months. If you compare it with the GDPR had given companies 2 years to comply from 2016 to 2018. Compared to that, India's Data Protection Act gives a much shorter timeline for companies. The reasoning was the minister said that the GDPR came at a time when privacy laws were new, and that's not the case anymore. So companies should be comfortable complying within a year. So that's about it for the Act. You can find more details of whatever we've talked about, more comprehensive details in the stories we've done. We can take any questions or get into discussion.
Rakesh, can we stop recording, please?